We turn on, okay. Well, we were gonna stay seated. Okay, that's fine too. Yeah, yeah. Okay, all right, great. Wow, I barely had to say anything. Thank you for being quiet at the appropriate time. Welcome. This is the showcase panel number 4. And the title of our panel is, Does Agency Regulatory Power Extend Beyond Its Formal Power, and Should It? I am your moderator, Judge David Stras, United States Court of Appeals for the 8th Circuit. And we've got, I think, a wonderful panel set up for today. And we're going to talk, I think, a lot about informal agency guidance, coercion by agencies, et cetera. I'll let the experts do most of the talking. But the way we've set up this panel, like many of the panels at the convention, is we've set up a 6 to 8 minute, probably an 8-minute opening presentation by each one of the panelists to sort of get their opening argument out there. Then I'm going to lead a short guided discussion and ask some questions. Maybe the panelists might ask questions of each other in the course of answering my questions. And then eventually we're going to open it up to the floor for questions from all of you, which is always, if not unpredictable, one of the most interesting parts of the entire discussion. So with that said, and again we're gonna start from my right and go to my left. Our first speaker today is the Honorable Boyden Gray, who's the founding partner of Boyden Gray and Associates. He's well known to many of you, I'm sure. He worked in the White House for 12 years. First as counsel to the Vice President during the Reagan administration, and then as White House counsel to President George H.W. Bush. He's worked on a variety of projects, and I'm going to talk about at least one of them that's relevant to what we're doing today. He worked on the original Executive Order 12291, requiring a cost-benefit analysis and White House review of regulations. During the presidency of George W. Bush, Mr. Gray was U.S. Ambassador to the European Union and the U.S. Special Envoy to Europe. He has also served as the chair of the Administrative Law and Regulatory Practice section of the American Bar Association. Without further ado, I will turn it over to Boyden Gray.
Well, Judge, thank you very much. I suppose it's appropriate that I'm on the right, at least from your perspective, and Sally is on the left. Sally rewrote the order I wrote, which is still the order, I think, so she can talk about it too. Maybe she will. And we were once partners, actually. So there's it's nice that she's on the other side. It is true I was special envoy for Eurasian energy. My last night in Brussels as the ambassador, I was invited by the head of the European Defense Force, which, by the way, doesn't really exist, to kerfuffle between Macron and Trump over that last week. I was asked to go to dinner, and even though he doesn't command much of a force, he does command, or did command, a nice house and a chef and a staff, and I couldn't go because I was packing up. But to entice me, he sent me the guest list, and I was identified as the Honorable C. Boyden Gray, U.S. Special Convoy. And so I felt that I had had a wonderful 3 years in Brussels making my point, which wasn't about convoys or about NATO. Do agencies project, assert more power than is formally right, and should they? They should not. Do they? Yes, they do. I think that the reason they do has been probably discussed already at this conference and in many other conferences. It's the interplay between the delegation issue and Chevron deference, but they do take advantage of, have taken advantage of that interplay to exploit so-called ambiguities to expand their power, and that in turn is used with all the other regulatory authority that they have amassed over the last 2 or 3 decades with respect to an industry or a particular company to basically scare people, spook people out of seeking judicial review. Now, this wasn't the way things were when I first came here, more years than I'm going to admit. Judicial review of agency action was considered routine and expected and not considered a cause of hostilities. But today it's considered bad, and the terminology is no longer judicial review. The terminology is, oh, you're suing the agency. Well, not really. I mean, it's part of the APA, the Administrative Procedure Act. It's normal. But they do it, and my favorite example is the combination of DOT and EPA and the California Air Resources Board spooking the automobile companies out of making any challenge to any rule, any guidance, any action taken by EPA for the entire Obama presidency. Now, that's quite a feat to prohibit judicial review of any action that hadn't yet even been contemplated by those agencies. Now, is this a hopeless situation? Well, of course, we can get into that, but until the Chevron thing is kind of cleaned up, the courts are kind of mixed up in this in a way that has got to be unscrambled. I want to focus for just 3 or 4 minutes on Congress, which is where this problem begins. And Sally might want to say, well, gee whiz, only the experts in the agencies can really handle these difficult situations, to which I would answer, no, I've sat through enough, and so has she sat through enough in the careers that we've had, which are about the same length of time, to know that Congress is perfectly capable, both through oversight and through the original legislation, to be precise and to pin the agencies down or keep them in their place. But they just haven't done it, and I mean, there are lots of reasons why. I ask people when I speak about this, and you can raise your hands, how many people have actually been engaged in a real fight in a subcommittee over whether an amendment is an amendment to the third degree? I don't see any hands. Well, back in the old days, that was often the biggest fight, and sometimes the most entertaining action in Washington was not a Supreme Court argument, but a subcommittee markup session where food was thrown and, all kinds of people were called in to answer a question, was an amendment to the third degree really an amendment to the third degree and therefore invalid or not? And everybody knew every word in the statute. It would have been impossible for anyone like Pelosi to say, we have to pass this legislation in order to find out what's in it. You couldn't get out of a markup without knowing every single word by heart. And that used to be the way it worked. Now, why has it changed? They go home on Thursday morning, they come back Tuesday afternoon. It's like a 2-day work week. And you can only do so much in a 2-day work week, especially when you have to raise all the money they feel they have to raise. So that is part of it. I don't know. There are other reasons for it. We can get into that in the Q&A. I don't have time to go into it now. But Congress has really been running away from its oversight role and its legislative role. And it has, in fact, encouraged agencies to expand, encouraged big business, which benefits, what Jamie Dimon calls Dodd-Frank. Jamie Dimon calls Dodd-Frank his moat. And by that, he doesn't mean his M-O-T-E in his eye. He means the water around his castle to protect him from competition. Now, Congress is capable of fixing these things, as I say. Heinzling got some legislation through in the last year, which lifted the regulatory burden that Dodd-Frank had placed on big banks, lifted it off of community banks, which had nothing to do with the crisis to begin with and couldn't afford to keep up with all the stupid regulations. And they've now started relending to small businesses, and that is part of the reason for the recovery. So Congress can correct things. It doesn't have to be the courts alone, and it doesn't have to be beating regulators over the head. Congress can fix it. Congress is perfectly capable of fixing it. But I think in addition to trying to live up to their own obligations, they're going to have to go back to a 5-day work week. I'd say one more thing. It may be that they actually purposefully leave statutes vague in order to encourage lobbying through the congressional offices to the agencies as a way of generating more campaign contributions. One sort of hint about this is the fact that after all these years, we still haven't been able to have the independent agencies covered by the executive order that I initially initiated and Sally polished up. This is sort of ridiculous in a way that these agencies, which now really do have a big hunk of the economy, are still so-called independent, and there's no legal reason in the world why they should be. It's just pure politics, and part of the politics may be the money. And so always follow the money, they said somewhere. And I think that's what one should do now. But Congress has got to go back to work, and I think a few swift kicks in the butt by the courts might also be helpful.
Thank you. Thank you, Boyden, for your comments. Our second speaker is Professor Nick Parrillo, professor of law at Yale. His principal field is administrative law, and recently he was commissioned by the Administrative Conference of the United States to study how the federal government's use of guidance documents, which the public often has a strong incentive to follow, even if they're not binding law, can be appropriately managed. My understanding is that his primary focus will be talking about the study and telling us about it. The study resulted in a best practices on agency guidance and eventually some testimony before Congress. He's also one of 40 public members of the Administrative Conference of the United States.
Thank you, Judge, and thanks very much to the Federalist Society for the opportunity to be here. As the judge said, I'm going to talk about this study I conducted for the Administrative Conference on the role of guidance documents in federal regulation. My working definition of guidance documents was a conventional one. That is, policies or interpretations announced by an agency that are officially non-binding and for that reason can be issued without notice and comment rulemaking. For the study, I interviewed 135 individuals across agencies, industry, and NGOs covering several different regulatory areas. Now, I should start by saying that very often regulated firms want guidance because it provides predictability in how the agency will make individual decisions. But also, sometimes, firms express concern that guidance practically operates like a binding regulation. My study aims to look into this concern in a way that is close to the concrete specifics of particular regulatory schemes. And what I find is that firms can face strong incentives to follow guidance, but it depends on the nature of the regulatory statute and on the structure of the agency and the industry. In particular, I find 4 structural factors that, when present, incentivize firms to follow guidance. So the first structural factor is pre-approval requirements. That is, the statute says the firm has to win the agency's affirmative assent in order for the firm to do its business. For example, FDA pre-market approval. Firms need the agency's assent and fast, and the best way to get that assent is to follow the agency's guidance. The second structural factor is if the firm has repeat interactions with the agency and the regulatory scheme is so complicated that the firm will inevitably fail to comply with some requirements some of the time. Under those circumstances, the firm wants to build a reputation in the eyes of the agency for being the kind of company that's trying to comply. That way, when the company inevitably fails to comply on some matter or other, the agency will interpret that noncompliance as a mistake, not as intentional. The firm can build up that kind of reputation if it generally follows agency guidance. The third structural factor is if the consequences of agency enforcement are so severe that firms do all they can to avoid enforcement even being initiated against them in the first place. That can be the case, for example, in markets where the market takes the initiation of enforcement as a signal that the firm cannot be trusted by its counterparties, or in situations where the credibly threatened sanctions against the firm in the event that it is found liable in an enforcement proceeding are so draconian that firms view settlement as the only option should enforcement get started. And finally, the fourth structural factor is compliance infrastructure. And by that, I mean that the firm has hired large numbers of compliance officers to be its primary interface with the agency, as has become the trend in certain industries. It appears that compliance officers, as a matter of their professional culture, are likely to put an especially high value on cooperation with the agency, compared with the culture of, say, in-house counsel. A firm that interfaces with the agency more through compliance officers may therefore follow guidance more. Okay, so those are four structural factors that push firms to follow guidance. And an agency official who issues guidance does not call these structural factors into being, and typically that official has no control over these structural factors. But the official may anticipate that the factors, when present, will cause firms to comply with any guidance that he or she, the official, issues. The four factors that I described are common, but they are far from universal. You can find regulatory areas in which the four factors are weak or absent, and in those areas, interviewees report relatively weak incentives to follow guidance. Examples of those would be FTC consumer protection regulation, CFPB regulation of non-bank institutions, or OSHA regulation beyond the largest employers. But even when these structural factors do operate, there's still a way of stopping the guidance from becoming practically binding. The officials who conduct the individual proceedings to which the guidance document pertains, the individual licensing decisions, the individual enforcement decisions, or the like, can be flexible in how they apply the guidance document. In other words, they can be open-minded toward arguments by regulated firms that the guidance document shouldn't be applied, either for general policy reasons or as applied to that particular decision. The more flexible and open-minded the officials are in these individual proceedings, the less coercive the guidance is, even if the structural factors that I described earlier are operating. But are officials flexible? Well, sometimes they are, but sometimes they're not. And we might assume at first glance that flexibility is the official's path of least resistance, such that inflexibility, when it happens, must be a sign of a deliberate effort on the part of officials to impose their chosen policies without notice and comment. But while there are some deliberate efforts like that, I think we should not assume that these are usually what is causing agency inflexibility where it exists. Officials in large bureaucracies, especially government bureaucracies, run into major obstacles to being flexible, even when they subjectively want to be flexible and recognize that they should be flexible. Let me discuss one such obstacle. An official in an agency, when asked by one firm to be flexible, will often be under pressure from other outside stakeholders who want the official to be inflexible, or, to use a different word, who want the official to be consistent. These stakeholder demands for consistency spring from rule of law values that officials would be remiss to ignore. If one firm gets a departure from guidance, that firm might get a competitive advantage. So the firm's competitors will want the agency to adhere to the guidance consistently to maintain a level playing field. Now, it is possible for an agency to be flexible while taking due account of these understandable demands for consistency. To do that, An agency that departs from guidance in an individual proceeding should announce the reason for its departure and make that reason applicable to all similarly situated firms going forward. By following this approach, the agency can keep an open mind to new arguments, but also keep the playing field level. There's just one problem. Formulating defensible reasons for departures and writing them up takes staff time and resources that are in short supply. So the agency may default to being rigid because rigidity is a cheap way to be fair. Now, you might respond, just have the agency do all its policy through notice and comment rulemaking. But that too runs up against shortfalls in resources. Or you might respond, okay, just have the agency not announce general policy at all. But that, of course, runs against objections from industry about how guidance is necessary for predictability in the individual proceedings that are going to occur in any event. So overall, the problem of guidance is shot through with hard trade-offs. The Administrative Conference has suggested managerial reforms to promote flexibility in a way that's principled and fair, but these reforms are costly. So priorities will have to be set. For example, allocating resources to providing flexibility in situations where structural factors, like the ones I described earlier, would otherwise impose very strong pressure to comply. That's just a sketch. Happy to talk about it more in Q&A.
Thank you for your comments. Before we move on to our third speaker, I do want to acknowledge that as with the rest of the program during the convention, this is being live streamed. So welcome to all of those who are watching us on the internet. Our next speaker, our third speaker, is a former colleague of mine from the University of Minnesota, Professor Kristin Hickman. She is an authority in the fields of tax administration and administrative law. She's the co-author of an administrative law treatise and a case book on federal administrative law. She is also a public member of the Administrative Conference of the United States. And as I said, she has the wonderful distinction of having started at the University of Minnesota 1 week apart from my beginning in 2004. I'll turn it over to my good friend, Kristin Hickman.
So what David neglected to say was that I started a week before him, with the result that then he had to take notes of the faculty meetings for the rest of the year as the junior first-year law professor. So I have to start with a couple of disclaimers. The first is that although I was invited to speak here today in my professorial capacity, I'm also presently serving as special advisor to Administrator Naomi Rao at the Office of Information and Regulatory Affairs. And my thoughts today are mine and do not represent the views of OIRA or Administrator Rao. I also have to mention that a lot of my thoughts today derive from an article that I'm presently working on with a co-author, Mark Thompson. So, you know, at some point when you're co-authoring, you lose track of which thoughts are yours and which thoughts are your co-authors, and they kind of get blended together, but I do think everything that I'm going to say. I do want to start by agreeing with Boyden and probably a lot of the people in this room that, at least on some level, we do have a guidance problem. Agencies too often use sub-regulatory guidance in problematic ways, leading to real-world consequences without offering affected parties the protections of public participation, APA procedural and process requirements, and pre-enforcement judicial review. The guidance problem contributes to perceptions that agencies are unaccountable and unfair and illegitimate. But I also don't think we'd want a world without guidance. The result is that the problem is complicated. The title of this panel asks whether an agency's regulatory power extends beyond its formal power. When we talk about an agency's formal regulatory powers, we mean the power to adopt legally binding regulations, and some agencies can also act with the force of law through and exercise policymaking discretion through adjudications as well. These formal powers come from statutes. If Congress doesn't give an agency the power to act with the force of law, then the agency doesn't have that power. By comparison, an agency's power to issue guidance derives not only from an act of Congress, but also from the Constitution's Article 2. When Congress enacts a statute and assigns an agency the responsibility of implementing and administering a statutory mandate or program, then the agency is constitutionally obligated to execute that law. The responsibility of executing the law necessarily involves interpreting the law, reaching conclusions about when the facts and circumstances exist that trigger rights and obligations, and making judgments about enforcement priorities. It is in all of our interests to encourage agencies to be forthcoming, to document and publicize their thinking with respect to these decisions. And this sort of transparency actually facilitates accountability and oversight. Moreover, regulated parties want guidance, as Nick so ably demonstrated. As I tell my students, prudent regulated parties and their attorneys seek every scrap of guidance they can get, no matter how informal, to help them understand the regulatory climate in which they operate and to make informed decisions regarding their primary behavior. So in addressing the guidance problem, how do we avoid throwing out the baby with the bathwater? Part of the guidance problem is that regulated parties want to be able to rely on guidance without being bound by it. And that position is sometimes a little bit difficult to square, at least as a matter of law. Talking about the guidance problem in the abstract is complicated by the fact that we have lots of different types of guidance out there with different degrees of authoritativeness, different degrees of thoroughness. Some guidance is so informal and equivocal with enough disclaimers that sensible people understand that it's not all that reliable, it's not especially binding in any real sense. Other guidance is authoritative. It's signed by agency leadership and it seems more definitive. Some guidance falls in the middle. It's not authoritative in that leadership hasn't signed it, but everybody understands that leadership has reviewed the guidance, that the guidance reflects leadership's opinions, and that agency enforcement staff correspondingly are going to follow that guidance faithfully. And some of that guidance, while not formally binding or even authoritative, uses unequivocal comply or else type language. Finally, we've got guidance that doesn't specifically dictate regulated party behavior, but nevertheless alters the legal landscape in which the agency and regulated parties operate, such that it has indirect and meaningful consequences. There's a tendency to want to resolve the guidance problem by pushing any remotely consequential agency pronouncement into the legislative rule box, with all the corresponding procedural protections. Sometimes that may be the right answer. But given the burden of those procedures, pushing too much guidance into the legislative rule box seems most likely just to curtail the flow of agency communications that people want, which just turns informal agency decision-making into a black box and actually diminishes agency accountability. So because I assume that Congress is not going to stop adopting complex regulatory regimes and relying on agencies to implement and administer them, my own answer to the guidance problem, which somewhat echoes what Boyden had to say, is pre-enforcement judicial review, applying the Skidmore and State Farm standards to a wider range of agency guidance documents. Maybe not all of it, but certainly the more consequential stuff. Congress, through the APA, has set up the courts as an important check against agency power. Courts can evaluate agency guidance documents for consistency with statutory meaning and for evidence of reasoned decision-making, holding agencies that act inconsistently to a higher responsibility under both standards, and invalidating the guidance if the agency can't satisfy these relatively mild thresholds. Now, maybe not every consequential guidance document is going to get to court, but the mere availability of meaningful pre-enforcement review will go a long way toward curtailing agencies' worst guidance practices and facilitating perceptions of the legitimacy of agency guidance. The primary obstacle to judicial review of agency guidance using the Skidmore and State Farm standards is finality doctrine, which often operates to keep guidance out of court until the enforcement stage. The Supreme Court historically has taken a pretty pragmatic approach toward finality that tries to look at the whole picture. But in Bennett versus Speer, Justice Scalia condensed the court's prior finality analysis into a two-part test that at least sounded narrower, and more legalistic. That test asks whether the agency action in question represents the consummation of the agency's decision-making process and whether legal consequences will flow from it. Interestingly, although Justice Scalia's language in formulating this two-part test sounded narrower and more legalistic than the court's earlier finality jurisprudence, his application of the test wasn't actually so. Regardless, too often, the Department of Justice has pushed the line, and the circuit courts have been willing to adopt a narrow understanding of the words consummation and legal consequences in that standard that essentially would limit pre-enforcement judicial review to legislative rules or guidance documents that a court thinks really should have been legislative rules and are being challenged as such. This interpretation of Bennett versus Speer is not consistent with the Bennett opinion itself, nor with the court's broader finality jurisprudence, including the more recent Sackett and Hawks decisions. But while not every circuit court decision has followed the more legalistic version of Bennett, nevertheless, the Bennett framing and its aftermath have they've had the overall effect of moving the analysis toward a more legalistic and less pragmatic conception of finality, with the result that conventional wisdom in administrative law circles now holds that guidance is not final, so it's not reviewable by courts on a pre-enforcement basis. In other words, the finality doctrine pendulum has swung too far in one direction, going from judicial activism that perhaps we saw in the 1970s or the 1980s, past judicial restraint and approaching judicial abdication in the context of agency guidance. We need to nudge finality doctrine back in a more pragmatic direction to allow courts to serve their proper role in ensuring agency accountability with respect to agency guidance.
Thank you, Kristin. Our last speaker, before we get into sort of a more interactive discussion, is Professor Sally Katzen, who's a professor of practice and a distinguished scholar in residence at NYU Law School. She has extensive, like Boyden, extensive government experience, having served in the Clinton administration as the administrator of the Office of Information and Regulatory Affairs and the Office of Management and Budget, Deputy Assistant to the President for Economic Policy, and Deputy Director of the National Economic Council in the White House, and then as Deputy Director for Management OMB. She also served as the head of the agency review group for the Obama-Biden transition, with responsibility for the Executive Office of the President and all government-wide agencies. Her wide-ranging experience with administrative agencies and the executive branch will surely add to our discussion today.
Well, thank you, and thank you very much for inviting me to be here today. I have always admired and commended FedSoc for including speakers with different viewpoints. And I truly appreciate you're willing to listen, in fact, to seek out somewhat unorthodox positions. I also appreciate the structure of our panel today, with Boyden and me being the bookends. We are, in many respects, bookends. As he said, we go back a very, very long way and have had parallel paths, working in the same law firm, having similar government positions. He drafted 12291, I drafted 12866, for those of you who like to rattle off the executive orders for regulatory review. We've been friends for years, although we agree and disagree about a number of things while remaining respectful. And I wish that that were a more frequent trait that we would find in this city, from my lips to his ears. Okay, to the subject at hand, I wanted to start with guidance because Nick and Kristin spent so much time on that. They've pretty much covered the field. I just want to emphasize a few things. As Nick said, agencies are turning to guidance, not out of ill will or aggressivity or grab for power, but for a number of reasons, one of which is the formidable process that's necessary to do rulemaking. See, in the APA, informal rulemaking is called informal. There is nothing informal about rulemaking today. Nothing. Aside from the notice and comment and reason and basis in the APA, there's the judicial gloss on those terms and what constitutes sufficient notice and sufficiency of the reason and basis. There are other congressional statutes that have been enacted, from regulatory flexibility, unfunded mandates, small business regulatory enforcement processes. I could go on. And then there are these wonderful executive orders, of which I'm very, very fond, that specifies that an agency has to say not only what it wants to do, but what information it's based on, and how the proposal will solve the problem, and what alternatives there might be, and the costs and benefits of those alternatives. Don't get me wrong. I don't disagree that these requirements are appropriate. I fully support those kinds of requirements. The consequence is better decision making, but it takes time. We're not talking months. We're talking years to do a significant regulatory action. So sometimes an agency might seek an alternative to notice and comment rulemaking. It might want to use soft power to push the boundaries, and there are tales to be told and anecdotes that are thrown around. And I'm not naive. It happens. Agencies do sometimes act too aggressively. But our ad law case books show that when this happens, the courts do step in. There are constraints, language about binding effect, either on the agency or on the regulated community, and there's remarkable consistency among the lower courts in what it takes to survive judicial scrutiny. So I would caution against painting with a very broad brush, condemning guidance as illegitimate. It might make people feel good, but I think that I think that this administration is finding that by being highly resistant to dispensing guidance, they're actually not advantaging some of those whom they would like to. As Kristin has said, guidance serves a very important function. It tells people what an agency is thinking, and better to be upfront and tell them than to have secret law. That has always been, I think, an important factor in this. Turning to Boyden. He says that during the Obama administration, regulated entities were scared or spooked out of seeking judicial review. As somebody who has to try to keep up on the cases that are coming out of the courts, almost wish that that were so. But there were an awful lot of cases that went to trial, that went to hearing in courts of appeals, and a lot of law. I believe the courts have been in play here. He also said that Congress could do a better job of being more specific and solving some of these. I agree. If we could solve that problem, I think we'd be going a very long way. But we have to remember when we look at this, and I think Boyden's real concern, if I may, is that the administrative state is too big. It's gotten out of hand. It's not controlled. It's nothing like what the founders envisioned. True. But this country has gotten very big. It has grown from the 13 colonies on the edge of the Atlantic Ocean with mostly white males making decisions. coming from agrarian backgrounds to a very big country whose economic interests lie in a global, I use the term global, economy, and who represent and include people of different races, genders, religions. It has gotten enmeshed in technologies that were unthought of. It is doing things that could not even be imagined. I remember in my youth reading comic books that were sort of sci-fi, science fiction. We are so far beyond anything in that, in the imagination of those people. And yet, our government has not truly responded to that. This may come as a shock to those of you who keep saying we need a smaller government. In the 1950s and the 1960s, we had about 180 million people in this country and roughly 1.8 million civilian employees working for the government. 180, 1.8 million working for the government. Over the next 50 years, we enacted laws, and I'm saying Congress enacted laws. These were not generated by the agencies. These are relating to auto safety, occupational health and safety, environmental protection, health care, just to name a few. A very few of the areas that Congress decided were appropriate areas and which the courts sustained. We now have roughly 325 million people, not quite double, and our federal civilian workforce is about 2 million, 0.2 of a point more than we had in the 50s. In addition, in the last several decades, we have seen straightlining or declining budgets for agencies. And the situation at many agencies is, frankly, appalling. When I got to OMB in '93, the State Department was using Wang. Only those who have very gray hair appreciate how out of date that is. Agencies do not have information technology comparable to the businesses that they are supposed to monitor in some respect. I mean, there's a lot of different issues, and that's another battle which doesn't come here. I just want to emphasize that the agencies are doing what they were told to do. That is the crucial phrase from Article 2 of the Constitution. Take care to faithfully execute the law. They're trying to do that. They make mistakes. Of course they do. But on the other hand, we have the courts, which is why this organization is so invested in, and appropriately so, the selection of judges. We have the courts that make a difference in this country. We have a judiciary that's dedicated to baseline norms of legal regularity. And the agencies have been kept honest, whether it's pushing back against Obama-era regulations, which some have said have gone too far, or whether it's chastising the agencies when they fail to keep faith with the law, as has happened by a number of courts with respect to Trump administration decisions to delay effective dates, to stay, to hold in abeyance, or to rescind existing regulations without following the appropriate course. The constant theme, whether it's pushing back Obama or pulling forward Trump, is the same: the law, as it should be.
Thank you, Sally. I've got a few questions that we can start with, and eventually we'll move to questions from the audience as well. I'm going to show a little bit of my own bias, and I use that term a bit loosely, but before becoming a federal judge, I was a state judge, and this will bridge a little bit of this morning's program as well. For 7.5 years, and in Minnesota, we had sort of one flavor of administrative law, and that was a regulation, which we all are familiar with. So far, I've been a federal judge for 9-10 months now. And it seems that in addition to regulations, that informal policy guidance comes, it's kind of like Baskin-Robbins in 31 flavors. So far, I've seen guidelines, handbooks, manuals, guidance, dictionaries, letters, opinions, and policy statements. And I'm sure there's a lot more out there. And they range from the very specific, which is a handrail needs to be so many feet off the ground, to general statements of intent about what the agency is trying to do. For those out there who don't specialize in this, and this is not my specialization, I'm a generalist, how should courts and how should litigants, when they encounter these sorts of things, what should they do? How should they treat them? And is this a good thing to have all of these different things out there? A lot of times I say to my clerks, so what's this? What do I do with this thing? And so I'm asking you, what do we do with all these different flavors?
Well, if you want me to give one short answer, just to repeat what I said, is that if you could get into court a little easier, people like you would quickly jolt and knock it down, but the agencies have this way of intimidating you out of even trying to get anything they do to you reviewed, because if you do ask for review, you better watch out the next time around they start to regulate you, or even watch it in this round. So there is real intimidation. I'm firmly, I've seen it's happened to me, and it's when you have no accountability and Congress is sort of asleep at the switch, agencies will do what they can do. Why not? It's a freebie, and so that would be my answer. The court thing, a suggestion for more pre-enforcement review. Well, I think that's a good suggestion. We tried that. To challenge, the CFPB, and we filed our action in 2012, and only this year did the Court of Appeals render a decision. Now that's 6 years, that's rocket docket stuff, The D.C. Circuit is not overwhelmed by cases. The reality, I think, is that even before the last 3 judges were added by President Obama, it had then the lowest caseload of any court in the country. Now I think it has really the lowest caseload. And I've been told about certain judges on the D.C. Circuit who schlep secretly around the country searching for cases to sit on, because otherwise they would grow tired of boredom. So there's room to do this if the agencies weren't, in such a retaliatory mode. That's my view of why the caseload here in the D.C. Circuit is so low. Doug Ginsburg once asked me, we were on a drive out in California to a conference, and he was then chief judge, and he said, "How come we have such a low caseload?" And I said, "Well, Judge, I think it's because the agencies are scaring people out of asking for your oversight, and you are partly responsible. Your decision in Business Roundtable versus SEC would spook any agency out of judicial review. So not sure I blame the agencies, but you started it. Anyway, no.
Others?
I certainly agree that guidance is very much non-standardized across lots of different agencies. It comes in all sorts of different formats with all sorts of different labels. The conventional legal definition of it at the federal level is that it's some communication or statement by an agency that falls into the bin of general statements of policy or falls into the bin of interpretive rules. But those are categories that are often I mean, they may be applied ex post by the agency when faced with litigation, if someone challenges them for why they didn't put a certain statement through notice and comment. And also they can certainly come up in the course of counseling within the agency. We want to issue this or that document with whatever name. Do we have to go through notice and comment for it? And then the agency counsel look at it and say, well, could we argue that this is a interpretive rule or a policy statement? So I mean, there's that lack of standardization. I think and there's all kinds of variation among guidance. Perhaps one of the most important dimensions of variation is whether the guidance is addressed to specific regulated parties in response to specific questions that, say, one company asked, or whether it is written up as a more comprehensive guide, more on the initiative of the agency officials. But I should note that one of those kinds of guidance often leads to the other. You may have the agency initially saying nothing about how it's going to interpret some regulation or exercise its discretion, but then you have firms calling up the agency, showing up and asking questions, and you have frontline officials giving individual answers. And then you have an agency manager saying, well, wait a minute, someone in this office is giving one answer and someone in the next office is giving a different answer. We need some consistency. And also, it's unfair that the people who show up get all this clarity. What about the people who aren't sophisticated enough to show up? Don't they deserve some clarity as well? And then you have the managers taking the initiative to write more comprehensive forms of guidance, a manual, as opposed to merely a series of letters that maybe are posted on the internet.
So, not to discourage you, but the IRS alone, my friend Don Korb, who used to be the IRS chief counsel, when he was done, wrote an article where he walked through all the different kinds of Treasury IRS guidance, and he identified 27, and they change periodically. They get rid of some, they start new ones. It's an impossible task, I think, to keep up with it all. I mean, not to belabor the point, but, so when a case comes in front of you, the only thing I think you can do, is two things: State Farm and Skidmore. Skidmore, does it, to the extent that it interprets the statute, is it consistent with statutory meaning? And under State Farm, is there evidence of reasoned decision-making? That can vary depending on exactly what the particular guidance document is trying to accomplish. It can vary depending upon whether the agency is being inconsistent, as sometimes happens from administration to administration, or as agencies just change their mind and try different things. But those two doctrines give you a lot of latitude while at the same time telling you what to do.
Yeah, I would join Nick and Kristin on this one. I think if it helps at all, the lack of standardization reflects to some extent the lack of standardization among agencies. Each is created by Congress for a specific purpose. It's given a specific mandate. Sometimes it's given specific tools. If not, it gets creative. But they have different tasks, and so you would not think that they would be uniform in any way. I always had thought of NPRM. I had finally gotten it down, Notice of Proposed Rulemaking. And then I heard about NOIs and other NOPRs and other terms that other agencies use. I mean, I guess at some point breathe. Accept the fact that there are differences and that we can live with them.
And sort of a follow-up question. I think we have a range of opinions on a great many things, but one of the things where opinions, I think, range here is I think that Kristin takes informal guidance as a given. I hear Boyden saying that informal guidance is generally a bad thing, and I hear Sally saying that, we live in a big country and maybe informal guidance helps. It helps guide behavior. And I guess my question, is to sort of get you all talking on the same page, not saying the same thing necessarily. I think that's impossible. But is it a good thing? What are the specific advantages if you think it's a good thing? And what are the disadvantages of a world in which much of law is governed by informal guidance, it seems? We're talking about, again, pages and pages of stuff out there on a whole host of topics.
Well,
Go
I'm just a broken record on this. Guidance is not only helpful in some cases, it's essential. And I'm not saying there shouldn't be any agency guidance. All I'm saying is that if there is a little stretch in that agency guidance, I mean, think of the rules now that are being, maybe this is a sore topic to raise at this point, but the rules that out of education which are giving people accused of assault the right to see the evidence and to face their accuser and do some cross-examination. I mean, what's so radical about that? Well, that was the result of a guidance document that obviously people didn't really want to take to court when it was issued. And why was that? Well, I've already said for the third time, I won't repeat it again, that people are very scared of suing the federal government now because it is so powerful.
Well, so I mean, I think the good point of guidance is transparency. You know, it's helpful to know what the agency is thinking, and through that transparency comes accountability. The real downside of agency guidance really has to do with the fact that it's not subject to any sort of procedural requirements under the APA. And those lack of procedural requirements, the lack of public participation, means that regulated parties who may feel they need to comply with guidance, if they think it's inconsistent with the statute, if they think it is predicated on mistaken understandings of how their industry works, if they think that the agency hasn't properly considered the consequences of what their interpretation of the statute would entail, they have nowhere to go. You know, they can't appeal to the agency because there's no notice and comment process. Sure, maybe they can send in a letter to the agency or object, but there's no formal process that the agency has to follow. Their only avenue is court as an alternative, or just going along with something that they think is flawed and wrong. And, you know, a lot of people, there's plenty of social psychological research that shows that if people feel like they have some sort of venue where they can air their concerns and have their concerns listened to, then even if they end up losing at the end of the day, even if the agency in this instance adopted a document that, or an interpretation that they think is wrong, nevertheless, that process adds legitimacy and people have faith in what's being accomplished. When you don't have that, you don't have an avenue for checking that agency power, then that leads to a loss of faith and a perception that government isn't on our side. So, you know, the APA doesn't require procedure for guidance for interpretive rules and policy statements. It explicitly contemplates that you're going to have guidance by having those exceptions. But it also sets up a robust process of judicial review on a pre-enforcement basis. Not you have to wait till the agency comes after you, but you're able to challenge what the agency says before you have to follow it. And I take Boyden's point that litigation takes a long time. But there's also to be said for agencies collectively can be trained, and if there are enough guidance documents that get castigated by courts on a pre-enforcement basis, then agencies are a little bit more careful about how they use guidance.
Shall we start taking some questions from the audience? Please feel free to, there's two sets of microphones, one up here and one back there. All right, let's go ahead and go to the first question.
My name is Miles Lynch. I'm a second-year student at the University of Pennsylvania Law School, and I have read both Professor Parrillo's report and the House Oversight Committee's Shining Light on Regulatory Dark Matter report, which talks a lot about the lack of uniformity within the administrative state and how different agencies have very widely varying procedures on how they publish guidance, how they make it known, et cetera. I'd like to push back on Mr. Gray and Ms. Katzen's point a little bit that there's been kind of congressional inaction and that this avenue hasn't really been explored because the Congressional Review Act allows or requires that guidance be submitted to Congress that could be validated, invalidated But one thing that's pointed out in the report is only 189 out of 13,000 plus, more like 30,000 guidance documents have even been submitted. So with judicial review not being available, and even if it was available, it's not illegally enforceable, it's what makes it guidance. And with the congressional avenue being present and not being used, what really can be done to increase uniformity and as really shine light on this issue?
Let me start on that, actually, because it was in my capacity as an advisor during the Clinton administration that I, quote, helped negotiate, close quote, the terms of the Congressional Review Act. And I beg strongly to differ with your reading that guidance documents were to be sent to the Congress as part of the CRA. The CRA was originally intended, and the language that was used in all of the discussions were rulemakings. Notice and comment, rulemakings, the same kind of concept that was going on under the Unfunded Mandates Act, which was being negotiated at the same time, and several other, the SBIFRA, some of the other statutes. It was not intended to cover guidance either in the form of a general policy statement or a manual or a press release or the chairman of a committee of an agency, head of an agency, giving a speech at lunch where he or she says, I think we have an obligation to look into X. That was never intended to be incorporated in CRA. So I wanted to just set out a slightly different interpretation of the statute. To your question, where do we go to get uniformity? I fall back on I'm not so sure uniformity is the ultimate objective. Because we have different agencies with different missions, with different mandates, with different resources, there are different styles, there are different techniques that are used, and while the judge might be disturbed that these things come with different titles and different names and different things, I don't think that that is the world's greatest problem or even this nation's greatest problem. And I think that if we're worrying about the rule of law, this might be on the third or fourth sheet of things we would list that we would want to have some sort of handle on. It's nice if everything is simple. Black letter law is terrific sometimes.
Well, if I would, now I'm going to break my own rule a fourth time. Political oversight is really important here. And let's leave aside the courts for a minute. Take Congress. I've said that they've, been AWOL, and it used to be there was a regular order process, both on the budget side and on regular legislation. And in the old days, I mean, what I'm about to describe was so common that, of course, everyone knew what you were talking about. Now I can't even remember the name of it. Somebody up here Sally was at OMB for enough time, so she should. But one of the early examples of a congressional review that knocked something out was OMB's issuance or knocking out of a milk marketing order. Now, you all sitting in the audience here said, well, what in the hell is a milk marketing order? Well, this is one of the wonders of American government, where in most realms of activity, if you agree to set the price of something or the amount of production, you go to jail. Marketing orders are just the reverse. If you don't agree to price fix or limit production, you go to jail. So, but OMB took that. Brian Mannix is laughing. He was at OMB when this took place, and they knocked out a milk marketing order, whereupon Congress immediately passed a rider, they were called, for forbidding. I think to this day it still applies, forbidding OMB to even look or think or dream about milk marketing orders. Another great example was the ignition interlock. There's probably no one in this room old enough to remember the ignition interlock rule, but this was designed to get people to use their seatbelts. And they had a big demonstration. I don't want to go into too long into this, but it's always struck me as very funny. They had a big demonstration down in front of the Capitol, I think General Motors and Ford showing off their new technological prowess. The trouble is, if you didn't get into the car in the right order that the software people had anticipated, you couldn't start the car. And everybody had to get out and get back in again. And it took 5 or 6 attempts to get the car started, and they couldn't get it in the right order. And within 30 days, the ignition interlock rule was zeroed out of the of existence. Now, this was a common thing when they used to have to come up with a budget. Once you get into, you get out of regular order and you don't do, budgetary items, you don't go through the budgetary process, there's no opportunity to get an override like that. But they were commonplace, and it ought to be commonplace again for the Congress to have the opportunity to do this when an agency gets out of line.
With regard to the role of Congress with respect to guidance, I mean, there's the Congressional Review Act process that you pointed out. There are also examples, at least occasionally, of Congress imposing some kind of process controls on guidance on at least an agency-wide basis, if not a government-wide basis. So, for example, in the late 90s, FDA was relying more and more on guidance to a large degree because the science was moving so quickly that it was difficult for notice and comment rulemaking to keep up with it. But the stakeholders said, look, we need some more quality control here. We need some more clear signal from the agency about which utterances out of agency officials are actually going to be, citable in review decisions or not. And we also, as the industry, want to have some input into the creation of all this guidance. And so FDA, to a large degree on its own initiative, came up with what it called its own good guidance practices, which would create more of a closed universe of identified guidance documents that were actually going to be applicable in adjudicatory decisions, and then also promised a kind of notice and comment light for those documents. In other words, the agency would take comment, but it would not respond, okay? The idea being that writing a response would slow things down too much, make it too much like legislative rulemaking. And Congress actually, it was to some degree because of congressional oversight pressure that the agency ended up deciding to do this, and then ultimately Congress ratified and required that procedural regime in legislation in 1997. So, I mean, it is possible for Congress, both through the oversight mechanism and through the legislative mechanism, to get more involved in this. I think it's a lot more feasible to do it and has a lower risk of unintended consequences if Congress does it on an agency-by-agency basis as opposed to a government-wide basis.
All right, let's actually go to the back of the room next, and then we'll come back to the front.
Great. Thank you. There was some bipartisan consensus earlier on the panel about the desirability of congressional clarity. Of course, Congress could choose to speak clearly anytime it wants to. It doesn't seem to have much of a desire to quite frequently. And right now, under the current status quo, anytime Congress doesn't speak clearly in a statute that gives an agency enforcement authority, that is presumed to be a delegation of interpretive discretion and authority to the agency to interpret it in any reasonable manner. If we want Congress to be clear, however, should we maybe not think about tinkering or changing that default background presumption and apply something like a penalty default, say, sort of a la Judge Easterbrook's proposal in statutes domains, that if a law is indeterminate on a specific point, the law just has no meaning, and the agency cannot act in that space until such time as Congress clarifies its purpose and meaning.
So 2 points on that one. First, I think you want to be clear. I mean, there are varying shades of ambiguity, and you're right that we do have this assumption on some level that some kinds of ambiguity represent delegations of policymaking discretion. But no matter how, given the nature of the English language, no matter how hard Congress tries to make statutes clear, there will inevitably be some ambiguity. And so saying that a statute's inoperative simply because clever attorneys are able to articulate 2 possible competing interpretations simply can't be the way that we make the law work. At least when we're talking about guidance documents, though, that presumption about ambiguity doesn't hold, because when we're talking about guidance, we're in the realm of Skidmore. That's the Meade case, which tells us that only when we're acting with the force and effect of law are we in Chevron territory. Otherwise, we're in Skidmore land, and we're looking for things like consistency, and we're looking for thoroughness of agency consideration. But also, courts remain the primary interpreters of the statute under Skidmore, not the agency. So I think that's an important difference to keep in mind, at least when we're talking about guidance in the post-Meade era.
I concur.
I must say this reminds me of a story that many of you have probably heard, but Skidmore and Meade, they're cousins or first cousins or siblings of our deference to an agency's interpretation of its own rules, which should have had some sort of statutory basis to begin with. And after one argument in the Supreme Court, this is recently, this is Justice Thomas telling a story about his friendship with Scalia after Scalia had died. That argument about our came up during the oral argument, and after it was all over, Scalia leans over to Thomas and says, that our decision, Clarence, was maybe the worst decision ever rendered by the Supreme Court. And Thomas says, yes, Nino, I feel your pain. You wrote it.
It's a true story. I've heard that story from Justice Thomas as well. Go ahead.
Hi, my name is Devin Watkins. So it's one thing in my mind to take non-binding agency guidance and kind of skip the rulemaking process, but it seems to be another to say that it's also immune from judicial review. And so my question is to Sally, do you think that under current law that guidance documents are immune from judicial review and not final? And should they always be subject to judicial review and challengeable as final agency actions in that way?
Well, I don't like any blanket statement, should they always be. I mean, cases come up and vary. No, but the answer to your first question is no, they're not immune. And that's why they're all in the case book of telling you where courts throw them out. If I said they should be immune, then I must have misstated, and I apologize.
I don't know that anybody thinks they're totally immune. I think the question is timing, and that's where the finality question comes in. There is, I think it's fair to say, if you look at the finality jurisprudence, I don't think there's any question that we've gone in a direction where, where more courts than not are, maybe they're not quite ready to put a blanket kibosh on pre-enforcement review of guidance, but I think they're less willing to find guidance reviewable than they were prior to Bennett versus Speer. I'm hopeful that after Sackett and Hawks, and after my forthcoming article, whenever I manage to get it out, that courts will decide to relax a little bit and find more agency guidance documents final and thus reviewable on a pre-enforcement basis.
All right, let's go back to the back of the room.
Thank you so much. Several members of the panel have discussed the lethargy of the federal government, both in inability to interact, the legitimacy questions about outdated equipment. I served in the Navy, and we were using, in the nuclear power field, instruments that were 20 years old by current nuclear industry standards. But doesn't that suggest that the government, in creating an agency, which I think some things should be agency regulated, like nuclear reactors, are picking one avenue to solve a problem when the market offers 359 other ways to do it? And a perfect example of this at the state level is insurance regulation of LASIK and rhinoplasty. No regulations on it. Insurance wouldn't cover it, and yet the market solved the problems far faster and more responsive to the public than agency and restrictive guidance would. So aren't there many instances where the agency really doesn't need to exist and where the market can solve the problem much faster with better legitimacy in the market?
Okay, I'll take that one. Perhaps. However, at least in the context of talking about sub-regulatory guidance, we're really talking about where Congress has already made a decision. So the correct avenue for reaching the conclusion about whether we need a particular agency, whether we need a particular regulatory program in the first instance, lies with Congress, not with the agency itself.
Yeah, anyone else? All right, let's go to the front of the room.
Right. I wanted to ask about the informal part of formal processes, which I think falls under the rubric of what you're discussing. I'm thinking particularly, and there are many examples, but in this case I'm thinking about, for instance, prosecutorial discretion or enforcement discretion. And I think anecdotally the case of Gaston Roberge in Maine, who allowed the town of Old Orchard Beach to put some spoils from road work on his dry property and was promptly charged with filling a water of the United States. And all was fine, and he would have been a disastrous criminal. And in the dock, were not a note found in the file where the agent bringing this forward said to his supervisor, "This would be a good one to squash and set an example." And I'm wondering if there's a space either through judicial review or possibly, ironically, through guidance to see that prosecutorial discretion is not used as a tool almost for unequal protection.
Well, on that point, I should say that when I interviewed enforcement officials or former enforcement officials, they, I think, on average, were most full-throated in their support of the agency issuing relatively clear guidance documents and adhering to them quite closely in ways that some people would say risk judicial challenge for inflexibility. And they actually said to me, I mean, these were people who had, managed enforcement at the EPA and that kind of thing. And they said, in order to elicit trust from the regulated population, you need to be transparent about why this party and not that party is being selected for enforcement, and you need to provide some assurance, especially to enforcement targets who are each other's business competitors, that if they settle with EPA on these terms, that the same terms are going to be offered to their competitor when their competitor walks in the door later. So, and I should also add that a lot of other observers who I also interviewed said, oh, the EPA Enforcement Office is much more inflexible about guidance than the other offices at EPA. But, the people at the office say, and yes, and there's good reason for that, precisely because prosecutorial discretion or enforcement discretion is so liable to abuse. And this is one of the areas where we really need consistency. And yet, it runs up against the principles of the APA that if you want to provide consistency, you have to go through legislative rulemaking, but then, of course, as I've said before, it becomes more difficult to provide guidance on a timely basis.
Any other comments? All right, we'll go to the back of the room.
Hello, thank you. I'm Dr. Jan Hamilton from Aspen, Colorado, with a case at the U.S. Supreme Court, as well as the Federal Court of Appeals for D.C. As we have navigated the agencies and the judicial review process, we have now learned that our challenges in judicial review in that court in the D.C. Circuit will now be sent to the 10th
I'm sorry,
Circuit.
could you stand closer to the microphone? Because with all the noise of the door going open in the hall, I haven't heard the last couple of phrases.
Okay, the matter that I'm asking each of you to look into your crystal ball and help us discern the justice that we all seek is now that Judge Merrick Garland has recused himself in matters before the Judicial Review Council for the Federal Circuit Court, and those are sent to the 10th Circuit. My being from Colorado and the case working its way through the 10th Circuit, we're questioning how justice will be done when our case now bounces back in the judicial review. Now, I served as a witness on October 30th at the Federal Judicial Codes and Disqualification Conduct over at Thurgood Marshall Judiciary Building. And so we are seeing America turn a page in history. And as the judicial review bounces away from this circuit and to a 10th Circuit, what should we watch for? What do you foresee as our country perhaps looks at impeachment, of disqualification of sitting judges? And just give us some of your wisdom to ponder.
Well, let me just, I'm not sure I understand exactly what you're talking about. Why would the disqualification of the chief judge, one judge of, I don't know how many who are on the D.C. Circuit now, why would one judge's disqualification bounce the case to the 10th Circuit?
Chief Judge Merrick Garland has has recused himself in a complaint filed against Gregory Katzen for non-recusal, and we know this week he did recuse himself in the Mueller investigation. So that judicial review matter will not be heard in the D.C. Circuit, but will now be heard in the 10th Circuit because Judge Garland recused himself of that matter. Of any complaints against Brett Kavanaugh, those will go to the 10th Circuit. So that's a new development. I'd like to just see what your insights are into how that happened and what might be the result.
You know, I appreciate the question, but it sort of strays a bit off topic. I'm not sure that it has much to do with agency, and certainly if anyone wants to address it, they're free to do it. But in terms of agency informal guidance, agency coercion, agency rulemaking, I'm not sure that that's what that question is about. So
the agency in question is the Metropolitan Police Department in D.C.
Okay. Well, unless anyone wants to take that question, we'll move on.
I threw away my crystal ball a couple years ago.
Yeah. All right, let's go to the front. Thank you.
Thank you, and appreciate each of your presentations so much. My name is Ken Klukowski. Building on the comments that Ambassador Gray made regarding the proper role that Congress should play in this process, and perhaps institutionally has not in terms of the legislation that underlies these actions. A question that I have, and I guess especially for Professor Katzen, given your role that you described with the CRA, what do you think of the theory that some people prominent with FedSoc have advanced, that under a proper understanding of the CRA, all rules must be submitted to Congress, and without that formal submission to Congress, they have no lawful effect whatsoever? Now, obviously, the implications of that are staggering when you think of how many rules have never been formally submitted to Congress, but it sounds like an intriguing legal theory. Would be interested in your response.
Well, I've debated that issue with some of the proponents from time to time, and I have, as I said, my recollection of what it was we were talking about, and it was far more limited than others might expect. I also know that there's a provision in the CRA that says nothing is judicially reviewable. And so I would suggest that this is a very interesting subject for debate, and I do not foresee resolution of it in the courts in my lifetime, which is getting shorter by the minute.
Anyone else? All right.
Thank you all so much.
How can we follow that?
Yeah, exactly. All right, to the back.
Thank you so much all for being on this panel. Elon Werman and Sandra Day O'Connor, College of Law. Kristin, as you know, I use your casebook in my administrative law class, and I have to confess that on the day we get to non-legislative rules, the distinction between interpretative rules that don't have to go through notice and comment and those that do have to go, the legislative rules, the students get closest to tears as they do anywhere. Now, it could be a contributing factor that the add drop deadline usually just passed. However, having said that, there's a reason for this. I myself get very close to tears when I teach this, because the real problem, it seems to me, is that the doctrine itself is completely incoherent and confused as to what is in fact an interpretative rule that doesn't have to go through notice and comment rulemaking, and what's a legislative rule that does have to go through notice and comment rulemaking. So there are two reasons, just for the uninitiated, why this is the case. So the APA distinguishes interpretative and legislative rules, right? But the Meade doctrine tells us that a trigger for Chevron deference, judicial deference to agency interpretations of law, is that the rule has gone through legislative formality, notice and comment rulemaking. So the Chevron doctrine basically treats these legislative rules as interpretations of statutes. So that's one problem. And then, because they're supposed to be different. And the other is the Chenery II doctrine, because the test for distinguishing interpretative and legislative rules is the American Mining Congress case, which says it's interpretative if there isn't otherwise a sufficient basis to enforce for enforcement. But Chenery II says there's always a sufficient basis for enforcement. The statute could be as broad as you want it to be. Chenery II says that's a sufficient basis, which also says that every legislative rule that has gone through notice and comment is actually just an interpretation of the statute after all and didn't have to go through notice and comment at all. So I guess my question is, isn't the problem that the doctrine has simply lost sight of how to actually distinguish between interpretative rules on the one hand and legislative rules on the other, that we have conflated two different activities, law interpretation on the one hand, and as you point out in your recent article in the GW Law Review, there's a different kind of activity, a policy-making power, an interstitial gap-filling power that agencies actually do pursuant to broad and open-ended statutes. In other words, if what's really going on is that 90% of the time, agencies, when they issue guidance, aren't actually interpreting law, but they're actually making law in the interstices of the broad statutes that Congress enacts, well, then 90% of current guidance should go through notice and comment rulemaking, because it's actually legislative. And for that other 10%, when it's actually interpretative, well, we all know that courts shouldn't defer to agency interpretations of law. So wouldn't that solve the problem, I guess? Or what do you think about that, to make it a question before the judge gives me another stare?
So there was a lot in that.
Sorry. Maybe that's why my students cry.
And I'm not going to try to tackle all of it. You and I can talk offline, Alon. But what I will say is, so the line between interpretive rules and legislative rules is incredibly murky. The line between what carries the force of law and what doesn't for Chevron purposes is, I would say, equally murky. I don't think it's just notice and comment versus not. What I'm suggesting is that trying to line up these different strands of doctrine like little ducks in a row so that they're all neatly consistent with one another is a fool's errand and actually causes more problems than it solves. It might be easy to do, but I don't think it's going to get us very far in any way that makes any kind of sense. We're always going to have trouble distinguishing legislative rules from interpretive ones. We're always going to have a little bit of trouble figuring out where at the margins an agency action carries the force of law for Chevron purposes. I just think the finality, deciding justiciability of a guidance document should be its own question, and I think should be evaluated in somewhat more pragmatic terms than our present doctrine regarding legislative versus interpretive rules or our present doctrine regarding Chevron versus Skidmore allows. And otherwise, we'll talk offline.
Thank you.
If I could, well, go ahead.
Well, may I ask a follow-up question of Kristin on this point that was brought up by the question?
Yes, please do.
I mean, could you say more about what you see as being the most promising place to draw the line between the guidance documents that ought to be subject to pre-enforcement judicial review and those that ought not? I mean, is it something about impact on regulated party behavior? Is that because I take it that's the underlying functional consideration that so many of us care about. I mean, do you think that should openly be the official legal test as well?
Well, so, and I'll admit that I'm still working out this part of the paper a little bit, but, if you look at the history of finality doctrine, before we had Bennett versus Speer that turned it into a two-part test, we had 5 factors from FTC versus Southern Oil Company of California. And some of the circuit courts, in trying to apply Bennett versus Speer, have added a gloss where they've drawn factors from SoCal and sort of used them to help understand and inform the Bennett versus Speer test in a way that makes it more flexible. And so part of it is that. I mean, you've got this question of, is it authoritative or non-authoritative, which I think adds into it a little bit. You know, there's also, you know, the question in terms of, you know, where, is there a place to go within the agency that's left? You know, that overlaps with exhaustion doctrine, but, you know, that's one of the questions from FTC versus SoCal. You know, so I think that the courts have the questions out there that are in the jurisprudence. It's really just a matter of not viewing Bennett versus Spears so tightly that you limit judicial review on a pre-enforcement basis to legislative rules.
Can I ask another question of?
Sure, please do.
You, I would hear from Naomi about, and others, Mark Pallett, about the huge fight going on with Treasury over interpretive versus legislative rules, and I never really got the details, and I'm dying to find out whether you can inform us of how you pulled it off, because we tried to get Treasury under the fold back in 1981 and failed miserably. Of course, that may be because I don't know why, but anyway, how did you do it?
I think part of it is that Susan Dudley and I co-authored an op-ed piece calling for that change.
Oh, okay, that answers that right.
Well, and I will also say that while I can't comment on that specifically, I've written a whole bunch of law review articles on it that I would be delighted for anybody to go read. They're all on SSRN. I've been talking about Treasury and APA compliance for 15 years.
One question that'll probably that I have, and we'll go back to the audience here in a second. But in the report, Nick, that you produced, or maybe it's in some of your articles, you talked about a stripped-down version of notice and comment rulemaking for some types of guidance, which I guess would further sort of shade the lines, make it more difficult to tell interpretive rules from legislative rules. But I'm wondering if you could address that, and then if anyone else has comments. I found that fascinating. Of course, it could run into Sally's point that it takes years to do that, although my understanding is you want to strip it down some.
Sure. So as I mentioned previously, the FDA is actually required to do that stripped-down version of notice and comment for its guidance documents as a matter of FDA-specific legislation. Several other agencies do it as well. The National Organic Program has a procedural rule that for an identified and large proportion of their guidance documents, they will do that. EPA does it on an ad hoc basis, making the decision document by document, but a substantial number of documents do go through that process. And then other agencies like OSHA virtually don't do it at all. So it really is a matter of the agency's own management decisions and its own kind of micro-politics, whether it does this kind of thing. I mean, I think there's, it's certainly possible for this kind of notice and comment to win some additional political legitimacy for the guidance documents. I mean, according to the people I interviewed, it tends to raise the quality of the policy that's being made just because it's better informed. You better anticipate implementational problems that the industry can tell you about if they have fair warning. I will say a pitfall that it runs into is this, and this is something that at times has happened at the FDA. If it's a regulatory context in which there are structural factors that create pressure to follow guidance, as there absolutely are at FDA, especially for pre-market approval, then if the agency does notice and comment on a guidance document and puts out the document in draft, and it says draft on it in red letters, the industry quite often will just start following what's in the document because they know that this is what the people at the agency would like. And regardless of its format, whether it be legislative rule guidance or draft guidance, they're going to be inclined to do it. The result is that the agency gets whatever shift in regulated party behavior it was seeking. And at FDA, at least, the people writing the guidance documents, the people obligated to process the comments coming in on draft guidance documents are also the people who write the new draft guidance documents. They're under all kinds of pressure from the industry to produce draft guidance where there's not even a draft. And that's what they're under pressure to do. And so they kind of shoot the next wolf at the door, and they start writing up new draft guidance where there's not even a draft, and they neglect to process the comments on the existing drafts and finalize those documents, which means that at FDA, sometimes a document will remain in draft for years. And this happens at other agencies as well. At EPA, there's guidance on power plant permitting that has been in draft for 28 years. This is a very authoritative guidance document other than the fact that it's in a draft. And really, it's a matter of, to a large degree, at least at FDA, it's the fact that they're short-staffed. They don't have enough. They don't have enough resources to both produce the new drafts that industry wants and finalize the existing drafts. And so you end up with comments kind of not being processed and not being listened to when they're made. So this is often a good idea, but the agency has to be resourced enough that it can actually execute the procedure in a meaningful way.
I would be remiss if I did not mention that during the George W. Bush administration, the Office of Information and Regulatory Affairs produced a guidance on guidance document in which it instructed the agencies, and it's in reference to the streamlined version, if it's a significant guidance, which means it would generally meet the terms and conditions for a significant regulation, then there is a requirement under the guidance on guidance to provide notice of what the agency is thinking of, take comments, and actually respond to those comments. It's virtually indistinguishable at some levels for some types of guidance from notice and comment rulemaking. You might as well just go through the ropes in the first instance. But if you're at an agency and you're thinking about this, you better check the guidance on guidance on guidance on guidance.
Yeah. I got to say, that's one flavor I have not encountered yet. It's guidance on guidance. Let's go ahead and this will have to be our last question, and we'll have to, the speakers, as I've been told by Dean and others, we'll have to vacate the room because we're going to start promptly at 4:30 for the next program.
That was a perfect lead-in for this, though, which is we keep making these agencies out to be these opaque, nebulous blobs, and the decisions being made within them are made by individuals. Yet I haven't heard any discussion on this panel really with regards to the role of individuals in terms of either making people more accountable within the agencies or how do you better utilize the individuals within the agencies.
Well, I personally believe that the career staff, the civil service, is an exceptionally good group, well-trained, thoughtful, analytical, and they do their jobs. And they work for the current president until 11:59 a.m. on January 20th, and then they immediately will work for the new president at 12:01 p.m. on January 20th. They are led, or should be led, by competent managers who, among others, are the political appointees. I think it's unfortunate that many of the slots are still vacant and cannot be attributed to foot dragging by the Hill, which has been very prompt in processing nominations. But there are lots of instances where the management competence or experience is not among the forefront of the qualifications for nomination. And I think that's most unfortunate.
Any responses from other panelists? All right, well, please give a round of applause to our panelists. Very robust and lively debate. Thank you very much.